Benson. We're located at 198 Thames Street in Groton, Connecticut. In addition to handling residential and commercial real estate, I represent 10 or 11 large property management companies, probably about a total of 3,500 apartments. And then I also represent what I call mom and pop landlords, and that could be anywhere from 100 units down to 1 unit. So today's webinar is being recorded. The PowerPoint presentation is going to be available to the membership after today. And if you have any questions, please feel free to use the chat feature. And you do not have to hold your questions to the end. I would more than welcome to have your questions while I'm making my presentation. So the first step in any eviction process is to serve the notice to quit. And typically we have a marshal do that, although the statute does say indifferent person. I have come across so many times where a tenant says, I never got it, meaning I never got the notice to quit, and so therefore I was not put on notice. That's why we have a marshal serve the notice to quit. I've had to put the marshal on the witness stand before and say, I physically delivered the notice to quit. Now, the notice to quit does not have to be served in hand. It can be served on what is called the abode, which is the house or the property. And these marshals are incredibly adept at getting that notice to quit in between the weather stripping and the door frame. They actually slide it all the way through, and I've seen them do it before. It's just amazing how they can get a piece of paper to slide through what it looks like a non-existent opening. Now, on the notice to quit, you have to put what is known as a return date. And the return date has to be at least 3 clear days. So what that means is you do not count the day of service, and you do not count the out date. So today is May 12th, and if I were serving a notice to quit today, I would put May 16th as the out date. So the day of service, the 12th, the 3 clear days, 13th, 14th, 15th, and then the out date would be the 16th. So yesterday was the 11th day of the month, which is either on all of your written leases in Connecticut, it typically says that rent is due on the first day of the month and you have a 9-day grace period, or if you have what's known as an oral lease, which is a month-to-month lease, then the Connecticut general statutes state that if rent is due on the first day of the month, then you have a 9-day grace period in order to pay your rent. So yesterday I block it on my calendar, it was a busy day. So my big institutional clients call in their notices to quit on the 11th. They don't wait until the 12th to 13th. Now, there are times where if I'm dealing with who I call the mom and pop landlords, I will tell them if your tenant has a good track record, meaning they've been there for more than a couple of months, there's no set or hard or fast rule, but you have to have a comfort level with the tenant, and they have to have a good reason why they're late. I mean, everybody runs down on their luck sometimes. So it could be a job loss, could be a reduction in hours, could be a spouse's job loss, could be an accident, an injury, something like that. You might want to cut that tenant a little bit of slack, but the biggest problem I see with the smaller landlords is that they wait sometimes. They wait until the 2nd month of non-payment or even the 3rd month of non-payment. And then I hear them complaining bitterly about how it takes 5 or 6 months to get the tenant out. But meanwhile, 3 months of that or 3.5 months of that is them just listening to the song and dance from the tenant saying, I'm going to pay you, I'm going to pay you. And that's why it takes now 5 or 6 months instead of 2 or 3 months at the most. So the notice to quit, again, is the required first step. And you can see I put some information down there, and I'm not going to read the screens to you, but it pretty much reiterates the information I just provided to you. And as an aside, I just want to state that my staff members who helped me develop this presentation had a really fun time with these images that are interspersed in between the written information that I provided. So we were going to call this seminar "Get Your Crap Out or Else," but we decided that wasn't a really good legal term. So the next step is after the summons to complaint, after the notice to quit has been served and the tenant has not vacated, you then need to go on to the second step. The second step is the summons and complaint. And virtually nobody vacates after they receive the notice to quit. It's either with 5 days they say, I can't physically do it, or if they've been evicted before, or if they know somebody who's been evicted before, some of these tenants, I mean, they're serial summary process people as far as I'm concerned. They know that they don't have to vacate. They know if they follow along with the system and respond accordingly, they're going to get extra time. So the second step is the summons and complaint. And that's the documentation that gets us into court. The summons is the first page in that set of documents. And in the upper right-hand corner of the summons, I have to fill in what is called a return date. And that's an arbitrary date that I pick. Typically, I will put, if I know the notice to quit is being served on the 12th, I'll put 2 weeks out for the return date. Now, the return date cannot be a Sunday, and it cannot be a legal holiday. But the significance of that return date is that it's a trigger date for the clerk's office. And I'm going to go follow up on that in 1 minute. But I'm going back now to the day of service of the summons and complaint. So it's 2 weeks out for their return date. During that 2 week period of time, the marshal has to serve the summons and complaint, process it, get it back to me, and I have to then get it back to court at least 3 days prior to the return date. So, and again, the marshal just has to serve the abode. He can serve in hand or serve the person if they're there. But you think about it, the legislature, it was a really smart thing when they said you just have to serve the abode, because people would avoid evictions just by not answering the door. So serving the abode is sufficient on that. Now, when I get that, the summons and complaint, and then have to return it to the clerk's office, God bless the state of Connecticut, the court entry fee is $175. The marshal fee for the notice to quit is anywhere from $30 to $40. The marshal fee for the summons and complaint is anywhere from $50 to maybe up to $70. So you can see within 6-7 days of starting this process, the landlords are incurring about $300 in out-of-pocket expenses in between the marshal's fees and the court entry fee. So now we've served the summons and complaint, we returned it to court, and as I indicated, that the return date is a trigger date. And the tenant and the clerk are notified, the clerk just by virtue of filling in the return date, but the tenant has instructions on that summons as to what he needs to do. But he is required, he/she are required 2 days after the return date to file either an appearance or an answer. They need to tell or notify the court that they received this paperwork and they are going to defend the action. Now, they might not have any meritorious defense at all, but they do have the right to defend the action. And I've seen everything, including the kitchen sink, as far as reasons why they didn't pay the rent on time. And I kiddingly say that tenants have a higher incident of deaths in the family, illnesses, cars breaking down, et cetera, than the general population. But I've been doing this for 28 years, and you know, I every now and then I'll see something new, but not that often. So during that 2-day period, the tenants are required to go over to court and to file an appearance or an answer. They have these pre-printed forms that are available for the tenants to fill out, and then if they do fill those out, they're required to put them in the mail to me. But if they do not fill them out on the 3rd day after the return date, keep in mind when I am listing all of these dates, when I say 5 clear days, when I say 2 days, when I say the next day after the summons and complaint gets served, that's in a perfect world. I mean, it could be that the out date is a Friday, and so the summons and complaint isn't going to get served until Monday. But meanwhile, that's a holiday, et cetera. So, you know, I do have a paralegal that dedicates her full-time hours to the eviction process. But I'm giving you, setting the bar really high for her by giving you just really, really tight dates. So now the tenant has failed to file an appearance or an answer. They failed to notify the court, as well as myself on behalf of the landlord, that they are going to defend this action. So we now have, as the landlord, have the right to file a default against the tenant. Now, if you're filing a default, it really shortens up the process if you're filing it and it's granted. In order to file that default, though, you have to file a motion for default, but you have to attach to that a military affidavit. You have to prove to the court's satisfaction that the tenant that you're about to evict and throw on the street is not in the military. And the policy reason behind that, which I totally agree with, especially down here in eastern Connecticut, you think about it. I mean, we've got a submarine base. I think it's 11,000 people are in between military and private persons working there. We've got a Coast Guard Academy. We have an Army Reserve base. So there's a very large military presence in eastern Connecticut. And the policy reason behind proving the person is not in the military before you evict them is they don't want you throwing somebody out on the street and all their stuff on the street, and then be in the middle of the Atlantic on a United States submarine defending our country. So I think it's a very valid reason why you have to prove they're not in the military. In order to do that, my larger clients or even the smaller clients, if they're filling out a rental application and they have the social security number of the tenant or tenants, they make my life a lot easier. I use a military locator service that if I plug in the social security number, they get back to me and say this person by this name and this social security number is not currently active in the United States military. That is good enough to have that motion for default granted. Now, if you don't have social security number, then if you know employment, if you know they're at Home Depot, Lawrence Memorial Hospital, Dunkin' Donuts, wherever, that's good enough because you're not going to be employed full-time and be in the United States military also. Now, a real-life example is I actually had a client call me yesterday, or a potential client, and they said that they wanted to evict the tenants in the property in Groton. So I asked them, okay, who are the tenants? He said, well, the two that I know, and that raised a red flag for me. So he gave me the names of the two that he knew, and I said, what do you mean by that? And he goes, well, I know that the tenants have allowed a couple of boarders to move in, and they're renting rooms. I said, how many? Two. Do you know their names? No. And I knew the answer to the next question was, do you know where they work? No. Do you know their social security numbers? No. But you know they're there. I absolutely know they're there. So I then informed him that before we served the notice to quit, I would really think it's a good idea for him to start going to that house. You go at dinner time, you go early in the morning, you go early on a weekend day, you knock on the door, and if you can get a tenant to answer, you ask them, hey, look, I need to know who the names of the people who are living in here for insurance purposes. I know you've got a couple of subtenants that are living here, and I need their names. And if by chance you get that information, the very next thing you're going to ask them is, oh, by the way, are you in the United States military? And if you can get a tenant to respond, no, Jane Doe and John Doe are not in the military, and nor am I authorized tenant or my spouse in the military either. That, as a fallback, that's good enough to put down on the military affidavit. I think it's beyond the scope of this seminar, but if you know somebody's in the military or you can't prove it, then you have to have an attorney appointed to represent that individual. and it really slows the process down, and it really increases the cost to a landlord. So now I filed the motion for a default, and it's been granted by the court. So what that means is, now if you think about it, so 5 days from the notice to quit to the out date, 2 weeks for the return date on the summons and complaint, let's say 3 or 4 days, because even though you can file it on the third day, you still got to get a judge to sign off on that motion for default, and they sometimes are busy for various reasons where they don't get to it for a couple of days. But let's just say it's 2 or 3 days, you file it after the return date, you filed your motion for default, and that gets granted. And what that means is now the tenant has what's known as a 5-day statutory stay of execution, and that means you don't get your execution signed for 5 days. You don't count Sundays, you don't count holidays, but once that execution gets signed, now that's the last step in the process as far as that tenant is concerned. That allows the marshals to go physically remove the tenant and their personal property if they don't voluntarily vacate. So in a default situation, you're really looking at less than a month. So that's why I tell all my landlords that, look, if you get a default, that's a good thing. It means you're keeping your costs down, and you're getting your apartment back, and hopefully getting somebody in there that's going to pay the rent that much quicker. So now I'm going back to that 2-day window, and now the tenant has filed an answer. They filed a response, and if they file special defenses, I have to respond to those special defenses. And by doing that, I've then closed the pleadings. So once the pleadings are closed, then you're waiting for the clerk's office to assign a court date for you. Now, in New London, in Windham counties, and Collin County too, for that matter, there is no dedicated housing court. In Hartford, in New Britain, in New Haven, you've got dedicated housing courts, and they are going every single week. The bigger cities, they're going a couple times a week, but we don't have that luxury here. And so when you close the pleadings, you're waiting for the clerk's office to assign you a court date. And it's usually 2 to 3 weeks out from when the pleadings get closed. Now, typically what happens is once I get the notification of the court date, and I could get 2 weeks notice, or I could get 5 days notice. That means I'm going to court on the landlord's behalf. And what I'll do typically is have my paralegal get together what I call my court math. So I have her work up numbers for me as to exactly how much that tenant owes. Do they owe April rent and that May rent? Did they have an arrearage before May 1st? Did they owe you a portion of March rent, February rent? Do they owe you maintenance charges? Do they owe you late charges? Do they owe you past water usage charges? If you have a written lease, they absolutely owe you, well, I shouldn't say absolutely. If you have one of my written leases, it will have in there that the tenant is responsible for any out-of-pocket expenses as well as attorney fees. So what that means is they'd be responsible for the marshal's fees, the court entry fee, as well as all attorney's fees. And then typically too, what I'll do is I'll have my paralegal find out if they made any payments. It could be they made a partial payment during since we started the notice to quit. So I want to be able to go to court and have a bottom line as to how much that tenant owes. So typically when I get into court, you'll go to court on that day, and the housing mediator will call the docket, and they just take them in chronological order. And it could be, probably the least I've seen are 5 cases. The most I've seen are 20 cases. And they'll call all the cases, and if both sides answer, then you go on the list to sit with the housing specialist. Now, in Connecticut, the first time you appear in housing court, you are required by Connecticut law to meet with the housing specialist. And the housing specialist is a state employee, and it's their job to sit and try to mediate these cases. I would say probably 90 to possibly up to 95% of cases settle, but occasionally you get a case that doesn't settle. And so what that means is when I am going to court on your behalf, if the housing specialist calls 5 cases and I'm number 5 on the docket and the 4 ahead of me have both parties there, typically I'll sit down with the tenant and say, you know, look, and I will know beforehand from either myself or my paralegal talking to my client, do they want possession back or do they want the tenant to acknowledge the arrearage that they owe and come up with a repayment plan. And so how that typically works is that, again, I'll show them all the money that they owe. And I have one big institutional client that they work with. Boy, they work with 95% of their tenants. They give them what I call the one free bite at the apple. And they will sit down and I'll give them my court math before I go, and they'll say, yep, you can work with them. So I'll take the amount that they owe, and I'll say, okay, here's what you owe. How much money do you have to pay for that today as we stand here in court? Sometimes they have the back rent, for example. Sometimes they have a couple of months' worth of back rent. And so I'll give them credit for that. I'll take the money order from that and give them credit for that. And then I will take the arrearage that they owe. Sometimes I divide by 12, sometimes 6, sometimes 3, and say, okay, in addition to paying your monthly rent, for example, it's now May 12th. Okay, you owe, I'm just going to throw numbers out there that are easy to follow along. You owe $900 for the arrearage, for all the back rent, the past due, the marshal's fees, the court entry fee, the attorney's fees. You have to pay your June rent by the 10th, and you have to pay $300 a month. Let's say by June 25th, $300. In July, you pay your rent by the 10th. June 25th, another $300. July 25th, and then the same thing for August. Rent by the 10th, arrearage payment by the 25th rather, excuse me. So if you do that, tenant, you will be reinstated as a tenant in good standing again. If you don't do that, then the landlord has the right to file what's known as an Affidavit of Non-Compliance. The court holds that for 72 hours and then issues the execution. Now, the execution, again, is the last step in the process. So, again, that allows the marshal to move them out. Now, if it's something other than, if it's a breach of rules of the landlord instead of a non-payment case, in the situation I just described to you where you have a stipulated agreement with the tenant, and by stipulated agreement, I mean the landlord signs off on it, and I do that on their behalf. The tenant signs off on it, and then the judge actually enters it as a judgment of the court. So if it's a situation where they allowed somebody unauthorized to move in, if there was an arrest in the apartment for drug dealing, for anything else, they actually set up a hearing on that. But with a non-payment situation, you'll get the execution pretty quickly. So that is the landlord-tenant procedure, with the exception of now that you can't get the tenant to agree to be reasonable. And they say, I want 3 months. And my response to that is, I want 3 months and I'm not making any payments. My response to that is, okay, see you at trial. The problem in New London / Windham counties, as I indicated, we do not have a dedicated housing court. And what that means is, and I don't advertise this, and I'd ask that you guys don't advertise this either, but what happens is, okay, I'm sitting in front of the housing specialist, the tenant's being unreasonable, I can't get them to agree to vacate within a reasonable period of time, then the file goes back down to the clerk's office, and it goes to the case flow coordinator and gets assigned a trial date. All trials as of right now in New London County are up in Norwich. They're at least 2 to 3 weeks out before you'll get your trial date. So you go to court the first time, now you go back to court the second time if you can't get the tenant to agree to vacate. So, and at that trial, the landlord has to be present. You have to have them there because you've got what's known as a burden of proof. You have to prove your case by a preponderance of the evidence, and I actually have to put the landlord on the stand to then go through all of the questions with regards to establishing the tenancy, establishing their obligation to pay rent, and that they failed to pay the rent. So again, 90 to 95% settle, but every now and then you get one that doesn't settle. And I've seen it all, but the most recent one that I had is we went to trial, and it's all public knowledge, but I'm not going to give you any names. But I knew the tenant, I can't recall who advised me of this, but one of my paralegals checked his name on the state of Connecticut judicial website, and he had been involved in a foreclosure that started in 2007, and he didn't pay rent from 2007 to 2014, and he was pro se. That means he's representing himself. So in the foreclosure matter, he's representing himself. He appealed it all the way up to the Supreme Court. He went 7.5 years without making a rent or a mortgage payment, and my client does not do a background check. Oh yeah, I knew his parents. His parents were really nice. Lets him move in, and bang, doesn't get paid. So I'm evicting a guy who hasn't paid rent or a mortgage payment in 7.5 years, and he was pro se. It was amazing to see the court log for all of the pleadings that have been filed. So ultimately, I got judgment, but the next thing I know, he's filing a motion to re-argue, and what he's doing by doing that is setting himself up to try to appeal the case. We were fortunately able to resolve it, and ultimately we got him out, but to be honest with you, I really thought this guy was going to damage the house. I really did, and I felt so bad for my clients because they were salt of the earth people. They were nice people, and they just rented to the wrong person. So with regards to that comment, if a tenant does damage the house, and I've seen it, the good news is for landlords, it happens really, really rarely. I have seen it before. The problem is when they do it, it's really egregious. There is absolutely a criminal law on the books that if a tenant willfully damages a landlord's property, he could be subject to criminal arrest. The problem is getting the police to enforce it, and the problem with that is that these police staffs they're understaffed, they're overworked, and I personally would rather that they go out there and enforce what I call the major crimes. But even in situations that I feel are really bad, they're going to turn around and tell the landlord it's a civil matter. Go pursue in civil court, which again doesn't help the landlords that much. So now I'm on the screen in front of you, which is the Affidavit of Non-Compliance, and I went over that. That's where you reach a stipulated agreement with the tenant. I'll sign it on behalf of the landlord. The tenant signs it, and then they try to make payments. So a lot of my bigger landlords, the bottom line for them is just that, the bottom line. They want to get paid. And by setting up these pay and stay type arrangements, they work. They work well over the majority of the time. So, and when they don't work, you've already got judgment against them. You file an affidavit of non-compliance. Again, the vast majority of times, you'll get your execution within 4 or 5 days, and then you have the marshal serve that execution. Now, I actually have seen evictions where this was the end result, meaning, but it was in a much more orderly fashion. This looks like all this stuff just got chucked out on the street. And in Connecticut, when a marshal serves the execution, they are required by law to give 24 hours notice, and then what they have to do is they hire movers on behalf of the landlord. So if you're in a move-out situation where you've got the marshal lining movers up, it costs the landlord. That's one of those exceptions that I cite that it's going to cost you a little bit more than your normal eviction, or sometimes a lot more, because you are required to remove the tenant from the property. So the marshal serves the execution. By law, 24 hours notice. Reality is, though, that they usually give more than 24 hours because they have to coordinate the move with the town's social services department, and they have to also line up movers. So while it says 24 hours, it doesn't happen that way. It could be as much as 5-7 days. And I've seen move-outs where it's cost thousands of dollars for the marshal, because the person was a hoarder and they had stuff from floor to ceiling, and you got to remove it all. Now, what the marshal does is these aren't white glove movers, but they are movers, and so they take the stuff, put it onto the moving van. They have to take it and from there and bring it to a town-sanctioned storage facility. The town then holds that for 15 days. If the tenant does not come back in and pay storage fees only, the town can then dispose of the property however it sees fit. So from the apartment or the house to the town storage facility, town holds it, and then the town gets rid of it if they don't come back and reclaim. But again, the only thing they have to pay are storage fees only. So the next screen, which is entitled CAPA notice, that is where you have a situation basically other than non-payment. You've got unauthorized occupants, you've got noise, nuisance, charged with a crime. One of the two first things I do in the morning, I grab the newspaper, I read the police log, and I read the obituaries, because I want to know who's going to be calling me that day. And you'll see in the police log, I know the addresses of my big institutional clients, and I'll see somebody get arrested for possession with intent. They did a drug raid or something like that, and I know that I'm going to be getting a phone call on that. Or if they just got arrested for possession with intent is serious nuisance. You can go right to the notice to quit. But if they just got arrested for possession, if they got arrested because there was a fight in the apartment or something like that, then you have to serve a CAPA notice. And the CAPA notice gives the tenant the ability to cure that conduct. And as long as that conduct does not reappear during the next 15 days, then they've cured, and they're still in there as a tenant in good standing. But if they don't cure during that 15-day period of time, or if the same conduct reoccurs during the next 6 months, you're not required to serve another CAPA. You can go right to the notice to quit. So security deposit is the next screen right after what I should have entitled this seminar, which was eviction notice, get your crap out immediately. Not a legal term, by the way. So security deposits. If the tenant vacates and they have met all their obligations to you as a landlord, and they provide you with their forwarding address, by Connecticut law, you as a landlord are required to return their security deposit within 30 days, as well as give them interest on their security deposit. So the trick is when they don't pay their rent in full, or if they move out and they have done damage to the property above and beyond reasonable wear and tear, then you are allowed to take that out of the security deposit. You still have to give them written notification within 30 days as to the disposition of their security deposit. So it could be they have a security deposit of $1,000, but they only owe you $500. So you have to give them notice saying, okay, I owe you $1,000, you owe me $500. Here's the $500 balance that I am forwarding back to you. And that's in a real simple explanation. The law does say that the tenant is required to provide written notification of their forwarding address. I tell all of my landlords to send that letter out to the old address because 99.99% of the time, the tenants have put a forwarding notification in with the post office, and it gets forwarded on to them. So if you do that and it doesn't come back, there's a presumption that they received it. And by doing that, what you've done as a landlord is you've limited yourself. In worst case scenario is you're in court arguing what was damage done by the tenant versus what's reasonable wear and tear. You've limited yourself to that argument. In other words, was I reasonable in charging $150 to repaint, or was that normal wear and tear? The problem is, if you don't do that, then you are subject to double damages. And what that means is, if you got a $1,000 security deposit, you could be ordered as a landlord, if you don't comply with the landlord-tenant laws, you could be ordered to pay $2,000. And when you go into small claims court, it's gotten a lot better, but I always say to my clients, when you go into the small claims court, you wear the black hat as a landlord. There's just, it has gotten better, but sometimes there's just no getting around the fact that you're a landlord and you don't get a break. So I've attached also at the very end of the webinar that this is a letter. Obviously you're going to need to add more information to it. You're going to need to put in details with regards to the tenancy, but that's a typical security deposit letter that I send out. So with that said, that is all of the material that I have for you today. If you have any questions at all, I'm happy to answer any of the questions that you may have. Again, as Catherine O'Leary informed me, who's sitting right next to me, the webinar was recorded, and my PowerPoint presentation is available to the membership. I've also attached in the very beginning of the webinar was my name, my contact information, my email address. So with that in mind, Catherine, any questions?
Nope.
So no questions, which means I either gave you really good information, which is probably just a remote possibility, or I talk really fast, which I know that I do. So again, if you have questions afterwards, please feel free to give me a call or to shoot me an email. But thank you very much, and have a good day, everyone.